Welcome, ladies and gentlemen, to the Saturday HOA Brunch, presented by Angius&Terry, LLP. Please sit back, relax, and join Brad Epstein and Jonathan Broderick for an hour of entertaining information about HOAs and HOA law.
And I also think we'd be a lot better off if we actually talked to each other instead of yelling at...
Good morning, Sacramento. I have an idea. Again, for the third week in a row, we're going to talk about the same thing we've talked about for the last 66 weeks.
What's that?
Community associations. Woohoo!
All right, community association. Well, yeah, real good information today. In general, the show is about community associations and only community associations. Join the conversation, 888-923-1380. Today we're going to talk about people, parking.
No. Just one P.
The people, pets, and parking. So we're going to talk about just the pets, right?
Yeah, and also I don't want you to cheat the listenership because I know that you're ready and you're excited to jump into talking about pets and community associations, but you're leaving a little important information out, and that's the text line, right?
All right, the text line, 916-747-4622. 916-747-4622.
Great. And you know what? Also, too, a couple things. Let's get some business out of the way. I want to, real quick, a guest of on our show, he called in. He was a fearless leader and a volunteer, and he passed away last month in our industry, and that is the former president of the Parkway, Ned Seal. Loved our show, always talked about it. He passed away last month. So real quick, I just want to take a minute. Or not a minute. We don't have that much time.
We know what you mean. A moment.
Yeah,
we
want to take a moment
to remember him.
A good friend of ours and a guest a few weeks ago,
guest on our
Michael
show.
Marshall, is the community manager for the Parkway in Folsom, and he announced this at an industry event this week that Ned Seal, had passed away. So I just want to take a minute and just say, hey, shout out to Ned Seal for his volunteerism. He was a courageous leader in his community. He was a guest of our show. He was a fan of our show. So way to go, Ned. And let's just dedicate this show to Ned Seal.
Let's dedicate this show to Ned Seal. Thanks, Jonathan.
Yeah.
Nice comments. Yeah, the Parkway with 10,000 trees, right?
Tons of trees. They've won awards for their trees.
Right. So if you have 10,000 trees, how many dogs do you have, right?
That's a good question.
That's not a good question.
Well, maybe what breed of dogs do you have? No. Okay, and the other thing is, too, we're going to give a shout-out to our good friend, right? It's our girl's birthday. Birthday weekend, right?
Great.
Deanna,
great.
What does she turn,
Community
42?
Association manager, right?
Yeah, 42 years old yesterday. Congratulations and happy birthday, Deanna.
Well, today we're going to be, again, focusing on pets. And this is, Jonathan, this is a big issue. We're going to talk about different examples. Probably the most popular example nowadays is where there's an association that only allows cats, pets other than dogs.
What about pigs?
They do not allow dogs or pigs as well. And typically it's a condominium situation, tight quarters. And the association gets a request from a resident. And the resident says, I want to have a companion dog. Companion
pets they're important, right? People have these illnesses or these psychological diseases, and they're saying, you know what? I need to have a reptile or a gecko or like a reptile, right? Like an iguana or a gecko or a snake because it makes them feel better.
Yeah. We have seen different types of companion animals, and what happens is it is a situation that a board of directors may be unfamiliar with, in that here they are, their job, maybe a new board member. What's their job, Jonathan? It's to protect, enhance, maintain the values of the properties, and one of them is to enforce the CC&Rs. And if the CC&Rs has a prohibition against dogs, then of course the association is going to be thinking, how in the world can they allow someone to have a dog in the association? So we're going to that's probably the primary example. We're going to be talking about that. Where are we going to get our information? We're going to get it from a couple of cases, right? The old cat case. What's that one, Jonathan?
The old cat case?
Yeah.
I'm going to say that maybe is the Narstead case.
The Narstead case.
Yeah, nailed it. First zinger of the day.
Right, so that is one of the biggest community association cases that exist, and it is a California Supreme Court case. We're going to also talk about the Terrifage case, so that's another pet case. And
Terrifage?
Terrifage.
Never heard of it.
Yeah, Terrifage. So it is actually Villa de Las Palmas Homeowners Association. Villa de Las Palmas Homeowners Association v. Terrifage, and it is related to the Narstead case in a couple different ways. In that case, the Terrifage case, 2002, and that date is relevant because in 2001, there was passed the pet law in your favorite group of laws that are called the...
Which one? I have lots of favorite groups of laws.
Davis-Stirling Act.
The Davis-Stirling Act. Yeah, the Davis-Stirling Act.
Davis-Stirling
My favorite.
Act, exactly. Civil Code Section 4715, we're going to talk about that. And we get a lot of our information regarding the subject because we're going to be talking about the law that associations must grant reasonable accommodations to the disabled so they have an equal opportunity to use and enjoy the development. And we get a lot of this information from two joint statements. It's a joint statement of the Department of Housing and Urban Development and the Department of Justice.
The DOJ.
Right, the DOJ and HUD, Department of Housing and Urban Development. And they put out two joint statements. One is about reasonable accommodations under the Fair Housing Act, and the other is reasonable modifications regarding the Fair Housing Act. So two situations. We're going to talk about modifications, accommodations, and this is in general the idea that when a resident asks for some kind of an accommodation to the rules because of their disability, the association has to do particular analysis. And in particular, this concerns companion
First
animals.
thing, just to throw it out, I hope that they do, the volunteers in the community, I hope what they do when that happens, the circumstance that you just stated, when they have to make special accommodations, is I hope they rely on an expert.
I gotcha.
You know what I mean?
No,
we'll just throw that out there.
So
who
would be the expert in this case?
Well, I don't know. You'd probably, if you were talking about for ADA compliance and access, isn't that what you originally had stated?
Right.
I would say that
not so much access. We're going to try and limit it to pets.
All right, pets. So then I would call the dog whisperer, that guy that's on A&E that trains dogs. What's his name?
I don't know that. I'm not aware of that.
Well, then, I mean, is there a pet expert?
I'm sure. There's an expert.
There might
for
be.
everything.
Frank Jolly, I think, said he's like, I know everything about everything, so we'll just call him.
Yeah. Well, good community managers, they have a lot of knowledge about what to do in these cases when an owner requests some kind of an accommodation to the rules, especially when it concerns companion pets.
Yeah.
Do we have one of our... also, we're going to play Battle of the Board Members.
Always. It's a staple.
Love it.
All right, so let's check in, right?
Yeah, I think we have one of our contestants.
Norm,
welcome to the show. Can you hear us okay?
Yeah, I hear you good.
Oh, loud and clear. Norm, it is great to hear your voice.
Yeah. Well, I'm ready to go when you are.
well, Norm, how long have you been a board member?
Well, two periods of time, 9 years altogether, 7 years, and then I had a vacation from board work. I guess in 2007 I left the board, and I came back 2014. I've been on the last 2 years now.
Congratulations. It's probably one of the most rewarding positions you've ever held before, correct, Norm?
Yeah, it is. It's very rewarding. It's challenging, and it's actually a lot of fun trying to solve the problems of the community.
How about in your community association, Norm, pets? Are pets an issue, or you're just not really? Or
well, not very often. Once in a while, we have a problem with dogs barking and things like that. Maybe cats get in other people's yards.
Nuisances is an issue.
But we have a pretty strict rules on keeping dogs and cats under leash.
That's great. Hey, Norm, we're going to go to break. The counselor's got a ton of great law coming up. He's going to educate all of our listenership. We're going to check in with Liz when we get back from the break. So stay with us, and we're going to be back shortly. Thank you.
If your community association has a good relationship with their current management company, you can stop listening. However, if you are struggling with your current service provider, we'd love to talk with you to see if Omni Community Management would be a good fit. Transparency, education, communication, and trust are just 4 of the qualities that set Omni apart. This is Rolf Crocker, CEO of Omni. Call us at 916-965-8964. That's 916-965-8964. Online at omni-mgt.com. That's omni-mgt.com. Omni Community Management, your friend in the community association management industry for over 20 years.
Have you ever heard of the saying, a person's home is their castle? Of course you have. But sometimes a construction defect can turn your castle into a catastrophe. If this happens to you, you need proper and professional representation. You need Angius&Terry, LLP. For over 30 years, the attorneys at Angius&Terry have been effectively serving homeowners and community associations, recovering more than $500 million on behalf of their clients. Angius&Terry strives to ensure that your construction defect claims are prosecuted in an aggressive and cost-effective manner. Angius&Terry will also continue to work with homeowners and community associations after the construction defect claims are concluded to make sure that the money received from builders is spent wisely and that your interests are protected during the repair process. Don't let a construction defect turn your castle into a catastrophe. Call Angius&Terry LLP today at 916-567-1400. That's 916-567-1400. Online at angius-terry.com. Angius&Terry LLP. Professional Parking Enforcement, or PPE, was created to provide effective parking solutions for all types of parking issues. PPE focuses on parking problems of HOAs and can quickly eliminate these problems through their system of property inspection, violation updating, ticketing, and enforcement. Contact PPE today at 702-283-0628, online at ppenv.com. PPE, promoting harmony in HOAs through parking and compliance enforcement. We take time to understand your community's needs.
Silver Creek Association Management.
We solve small problems before they become big ones.
Silver Creek Association Management.
We help make your community a better place to live.
Silver Creek Association Management.
It's what we do, because an association is more than just a bunch of homes. It's a community of people. We work with you to make better communities so homeowners can enjoy better lives.
Silver Creek Association Management. Online at sc-manage.com. That's sc-manage.com.
AM 1380, The Answer.
Welcome back. Interesting song. That is Frank on the Sticks. I think that's a actual recording of Frank.
He always throws curveballs at us.
Yeah.
I said, you know what, we're talking about pets. We want upbeat. We want some spiciness. We want some sizzle. And then all of a sudden we come in with this acoustic.
You're listening to the Saturday HOA Brunch presented by Angius&Terry, LLP. And now your hosts, Brad Epstein and Jonathan Broderick on AM 1380, The Answer.
Well, I think we're back.
I hope so.
I love that music.
Well, at least we know the waves are rolling and we're getting ready to go surfing, right?
Have you ever seen a surfing dog?
I have.
I know
on
you have.
YouTube.
Yeah.
Why don't you do us a favor?
Or that one dog, that bulldog that is on the
set a Guinness World Record
on the skateboard,
and he goes through all those people underneath there. Like,
all right. Well, we're back with the show. We're gonna go ahead and we're gonna welcome Liz to the show, and Liz is a fantastic board president. Liz, welcome to the show.
Thank you very much. Good morning, Brad.
Good morning. And we don't have to actually name names, even though they deserve it, but when an association is victorious, when they succeed in litigation, in a lawsuit, I think that they should pat themselves on the back, especially when someone tried to attack them and they fended them off. So, Liz, you were at the court case when you won just a week ago, right?
Right, exactly.
So what we did is we prepared. We got an expert witness. You have a fantastic manager. We put it all together, and it wasn't a pet issue, but it was a contractual issue, and the association was successful. So great job. You want to say the secret to your success? Is it your fantastic advocacy? What was the victory? Because I haven't been able to talk to you.
Well, we have an excellent manager, and I think the company is excellent. But she did such a wonderful job, and I think, and then just getting all the background and that type of thing. I think that's why we were successful.
Excellent. All right. So that is just one of many successes and victories that will and has occurred with respect to your association. So welcome to the show. We're going to listen up and talk about the law, and then we'll have battle of the board members at the end, and we'll explain that.
Counselor,
Okay.
you know what? And Liz and Norm, and I'm really happy because I know this is one of your staples in community and building a sense of community is you're one of the guys in the industry that says, you know what? Community associations, when a board or something has something successful happen, you're one of the guys that stands up and you say, yeah, you need to celebrate the success, right?
I think that is
Right.
true. Yeah.
Absolutely.
Great.
Okay, so what we're going to do is first, since we're talking about pets and companion pets and service dogs, let's first talk about the 1994 California Supreme Court case of Narstead. So in Narstead, this was a condominium case, and it's one of the grandfathers of all the cases. In this case, a homeowner had some cats, and they were indoor cats all the way, Jonathan. Indoor cats.
Really?
All the way. At a condominium association, but the condominium association, CC&Rs, they prohibited cats. And the owner's main argument, I can keep my cats because they stay indoors. This rule is not reasonable. This rule in the CC&Rs, why is that enforceable against me? So many arguments. This case went all the way up to the California Supreme Court case, which means it has to go through a trial. It has to go, or at least a decision by the trial court. It has to go up to the Court of Appeals, and the California Supreme Court has to take the case up. California Supreme Court can pick and choose what cases it wants to take up. There are not a whole lot of community association cases out there, you guys. So when there are, those in the industry make a big deal out of it and really analyze it.
And they publish them, right? And write opinions and all that good stuff.
Right, different analyses of it. So in the Narstead case, so what does the California Supreme Court case do? They said that CC&Rs are valid and enforceable unless proven unreasonable. So it was the case that said CC&Rs must be obeyed. There's a presumption in the court that they are enforceable. So let's say an association is suing an owner for an owner's violation of the pet restriction. Pet restriction, we'll say, is where you can only have 2 pets, right? And so in this case, the association CC&Rs say you can only have 2 pets. Association sues an owner, and the association, they have a presumption already that the CC&Rs are enforceable. So can you see the difference between that and when the association would have to prove that their CC&R provision is reasonable? They would have that burden. Can you see the distinction?
I see the distinction, and I would just assume that most boards of directors that we work with are great, and they're reasonable, and they want to come to a conclusion and resolve an issue before it would ever go up to the level of the Supreme Court. So they're going to first enforce, you maybe send some letters out and do a couple of things prior to going ahead like this Narstead case and just saying, let's do it. We're suing you for having too many cats.
Oh, well, right, because there are many steps before a association can bring their dispute to court anyway, right?
Right.
We have the internal processes, and that would be warning letters. It would be whatever their enforcement policy says. It must include a hearing, a board hearing, and what is the requirement in most cases before an association can file a lawsuit? What do they have to?
They usually have some sort of mediation.
Right.
So they're either going to have, depending on the process or whatever they have written into their documents, maybe I'm assuming they're going to say, well, we're going to do like a IDR before, like internal dispute resolution, or ADR. It just depends. It varies.
Almost,
per association.
right.
Almost.
Let's
I'm not an attorney, so
right.
go ahead.
That's the first zinger. So you're pretty close. So the idea is that the association, if they have some kind of internal dispute resolution provision in their enforcement policy, then they would have to go ahead and do that.
And some
However, it's not a
associations-
requirement for an association to sue.
But they have, some associations actually have that written out, right, and set in stone that, hey, we're going to resolve things this way first. If that doesn't work, then we're going to go ahead and boom.
Yeah, I wouldn't say it's set in stone. I'd say it might be in a rule which can be changed by the board of directors.
There you go.
If it's a CC&R, you need a vote of the owners. But an association, in most cases, must ask the owner to participate in ADR in order for the association to sue.
That's Frank's favorite.
Okay? Right. All right. So that's the Narstead case. And then we later on.
So what happened in the Supreme Court, though, with the Narstead
yeah.
case? Real quick, just what did do you know the judge order? So then he gave an answer to everyone and resolved it in the Supreme Court. What happened?
A big argument. That's
Big
right.
argument.
And the Supreme Court said that the provision in the CC&Rs prohibiting cats was valid and enforceable, regardless of the fact that the owner said they never took the cats out. And one of the things that the court did look at, before we move on, is that in the case, the courts, how they analyzed it was, again, that burden, the presumption. And so valid and enforceable are CC&Rs, which brings us to the Terrafage case. So the Terrafage case, a little bit different. In this case, the association, they adopted a rule, a rule, not a CC&R provision, so the board of directors could go ahead and do that, and it was a prohibition on dogs. And an owner gets a dog, and the fight proceeds into trial court. The association says you can't have the dog. The owner says, I want the dog. And so the trial court, they said, well, association, I don't think you're going to win this one. I don't think you're going to win this one. So the association, what do you think the association did? And it's a real strategic out-of-court move. So you follow me so far? So it's in the trial court. The association files a lawsuit against the owner saying, hey, we got a valid rule here prohibiting dogs. And the owner files a motion says, I don't think so. The trial court said, association, I don't think you're going to win. So what do you think the association did as a strategic move?
Well, I don't want to get out of line here, I know, but you'll slap me right back into shape. Was the owner's request for this dog, was it because it was like a companion pet or was a service animal?
No,
not
like
at all.
That. No,
not at all.
No.
I'm going to say
that claim.
The board of directors huddled up and they said, you know what? We have solidified our governing documents. They're enforceable. They are law. So we're going to stand tall.
But no, I'm going to give you another quote. They did a strategic move, out of court strategic move.
They hired an assassin. What? I don't know. I mean,
what they did is they went ahead and they had the owners do a CC&R amendment, approve a CC&R amendment prohibiting dogs.
What? And they got it through because that can be tough sometimes. That's a timely process. Occasionally,
during the court case.
Yeah.
During the court case.
Really?
Mm-hmm. And so the case went up to the Court of Appeals. And the court said a CC&R amendment that prohibits pets is just fine because the owners voted for it. So it gave it some extra impact based on the Narstead case in that the presumption is CC&R provisions are valid and enforceable. In this case, even an amendment is valid and enforceable. And now what the court also said is the court said, well, we would have said that the rule was enforceable as well. So good decision, Terrafage, but we cannot talk about Terrafage without talking about Civil Code Section 4715.
One of my favorite Civil Code sections.
Right. So that is the Civil Code section on pets. It is a new 2014 section number. So it was changed before, but when do you think that 4715 was originally
adopted?
Was adopted into law, right?
I'm going to say early 80s.
2001.
Oh, okay. So I was way off.
Right in the middle of this Terrafage case. And so what this case is, it's a pro-pet Civil Code section 4715. It's pro-pets, and it says that no governing documents shall prohibit the owner from keeping at least one pet.
Really?
Subject to reasonable rules and regulations of the association.
So this is one of those trumps, right, where that comes in and it says state law, federal law, overrules the governing documents.
But the interesting part about this law is its grandfather clause. So we'll talk about that when we come back, right?
Excellent. We have Liz and Norm on the line. They're diligently taking notes. They're ready to duke it out. We've got the counselor in here just crushing it on pets today. So we're going to be back from the break. We're going to wrangle Frank Jolly in, and we're going to continue talking about community associations. So stay with us.
Having trouble understanding your community association's reserve study? Does your HOA's reserve study seem to be written in a strange language? Hi, I'm Robert Browning, owner of the Browning Reserve Group. At the Browning Reserve Group, we have been providing easy-to-understand reserve studies since 1999. We actually listen to our communities and help them plan for the future. Find us online at browningrg.com. That's browningrg.com, or toll free at 877-708-0600. That's 877-708-0600. Clarity from complexity, the Browning Reserve Group.
If you are a community association or manager, you know your banking relationship is vital to your success. At Sacramento Bank of Commerce, a division of Redding Bank of Commerce, our industry expertise and personal attention make that task a breeze. With our specialized banking, lockbox, online banking, and remote deposit capture, trips to the bank are no longer necessary. And Sacramento Bank of Commerce can help your communities with a loan to repair, replace, or upgrade the investment. For local decisions and in-house processing, get in touch with our team today. Call Sacramento Bank of Commerce at 916-772-0131. Member FDIC, Equal Housing Lender.
Did you see the story about the Homeowners Association? I wonder what their residents think.
I don't know, but I love my condominium association. The place looks great and is well managed, and our property values are increasing.
Well, that's a good thing.
Community Associations Institute, CAI, has helped us build a great community. They have tools for safeguarding our investment, including education for our board and professional training for our manager. Just visit CAI at responsiblecommunities.com.
Okay, responsiblecommunities.com.
AM 1380, The Answer.
You're listening to the Saturday HOA Brunch presented by Angius&Terry, LLP. And now your hosts, Brad Epstein and Jonathan Broderick on AM 1380, The Answer.
Good little jingle coming back from the break. That's all right. Just slide the mic over. It's okay. You had an important text. You were responding to the text line. But I want to finish this up. You kind of left a little cliffhanger for the listeners, and you said, you know what? We're going to talk about grandfathering when we come back from the break.
Right. So we're still on the one pet law in the Davis-Stirling Act, Civil Code Section 4715, entitled Pets.
There you go.
All right. So 2001, we get this law, and what it does is it says that no governing document shall prohibit the owner from keeping at least one pet.
And this is
subject to reasonable rules and regulations. What would be a reasonable rule and regulation, Jonathan?
A reasonable rule and regulation, depending state by state. We'll dig in here, right? But
no, what am I doing?
Well, it varies. What you're shoveling.
What am I shoveling?
You're shoveling snow.
Dog poo.
Dog poo.
Okay.
Dog
right.
poo. I didn't really want to talk about dog poo on the air, but
it's important.
All right. So listen. But here's the deal, right, Counselor? Because some boards of directors in other states...
You were just admonished by Frank Jolly.
Well, that's
on
fine.
The sticks.
That's whatever.
He wants
to
language.
do. Frank, go grab another drink in the break room.
Watch
We're talking,
your
all right? So listen, some boards of directors would say a reasonable rule is, well, you can't park your car in the driveway. Right?
Okay. Well, okay.
Now, but then you're saying is a reasonable rule. Go ahead, ask me the question one more time so I can filter this and give you...
I just asked you for an example of a reasonable rule.
See, that one...
regarding
varies,
a pet, and that is
right.
you have to clean up after your pet. Right?
I think a reasonable rule would be you can't have rattlesnakes in your HOA. That'd be reasonable. That would be a rule that I would write in.
Well, hang on a minute. Do you really think someone would keep rattlesnakes?
Maybe. There's some crazies out there.
They sell the venom or something?
Yeah. So for me, a reasonable rule.
All right. Well,
that's I'm just telling you. You said find me a reasonable rule.
Okay, hang on. We got a
reasonable.
text, and we're going to answer the text.
Right.
And actually, I was going to go to that anyway next. So this pet law, 4715 in the Davis-Stirling Act, it provides, it defines what a pet is. All right. So here's a pet: any domesticated bird, cat, dog, aquatic animal kept within an aquarium. Within an aquarium.
Bring your seal
aquatic,
over.
Though, aquatic, right? Okay, so that's
right.
water. Or other animal as agreed to between the association. Okay, so you can agree to go ahead and include particular pets in your association. For instance...
Wait a minute. Say that again, the reason. Well, just give me this again.
Sure.
That's because I'm
all right, so
enjoying this.
Right, so we're talking about the Davis-Stirling Act. This is the pet law. It's 4715, and it says that... and we'll get to the grandfather clause in a minute, but in 2001 it said that, came about, and it said that associations they must allow people owners, residents in their association to have a pet. And then it says what we mean by pet is domesticated bird, cat, dog, aquatic animal, cat within an aquarium.
Or Frank Jolly.
So if it's something like you said, like a venomous snake, then it doesn't fall within the protections. Okay, so the grandfather clause, it's about time, right? Okay.
Yeah.
Okay, so this section we're talking about, it became operative January 1st, 2001. And it only applies to governing documents entered into, amended, or otherwise modified on or after January 1st, 2001. You see that? You see how it grandfathers in governing documents before that date, before January 1st, 2001.
Question, and I don't mean to throw zingers out this late in the show, but where did this come from? What court? Is this a state law? Is this federal law?
This is the Davis-Stirling Act.
No, I know.
Civil Code
but
section.
What I'm saying is who initiated this? Who initiated the revision to the Davis-Stirling Act in 2001?
It was just an amendment.
Okay.
Yeah, and it was just a law that came about as on behalf of, I'm not sure who sponsored it, and I'm not even sure who actually was the assembly person or Senate.
Well, because the only reason I asked is because, unfortunately, in the society that we live in, our legislature is actually pro-property owner, right? Like anti-tenant. So they have a lot of laws in place that protect some slumlords, some good landlords. But I think that
this is your opinion.
This is my opinion. I think that our laws weigh in heavily in favor of the property owners.
You do.
I do.
I do. I would say that a lot of property owners would differ with you.
Really?
Jonathan. I would say that a lot of property owners or people in general would say that the laws in California favor a tenant over a landlord. All right.
Well, but that's 1 out of 50, right? States.
Okay, so let's go ahead and we need to move on to now when a owner or a resident or a tenant at a community association comes to the association and says, I want to have a service animal. Or I want to have a companion animal. So what's the difference between a service animal and a companion? Let's get some definitions out there.
Well, I'm reviewing because one of our good friends and one of our writers, Mr. McPherson, he helped to give me a couple of different definitions of this. So I'm going to take a crack at it real quick. I'm going to say that a service animal is a necessity to help you with your day-to-day living, right? So if you're blind and you need a dog to guide you, or if there's a lot of different descriptions.
That's pretty good. It's a trained
animal to
assist a disabled person.
Right. And then I'm going to say companion animal is
you got
something
that one right.
that anybody can get. If they want to call somebody up, they just say, hey, psychologist, like I need 3 parakeets. They help keep me happy, and they go out and they get it.
Sort of. Okay, so what you have is, first of all, you're correct with the service animal in that it is an animal with skills to help the disabled. So a companion animal, in contrast, is an animal that helps disabled but has no skills.
No skills. Exactly.
Untrained.
Except their maintenance. You got to clean up after them and all that good stuff.
All right. So to look at now the best source out there in order for an association board of directors, manager, to determine how to deal with requests by owners for accommodations to the rules to give the owner, resident, tenant an equal opportunity to use and enjoy the association. Okay, so they come to the association, they say, I want something because of my disability, and it comes from 2 really good publications. One of them is the joint statement of the Department of Housing and Urban Development and Department of Justice, Reasonable Accommodations under the Fair Housing Act. So it is a FAQ, and you can get it right on the internet, FAQ of everything about when an owner comes to the association and says, I want to have a companion pet.
Well, and that's tough, right, for the board of directors to even kind of put up a strong opinion.
Well, because you're right. You're trying to enforce your CC&Rs, our example at the beginning.
Yeah.
This association, our hypothetical is where you can have cats but not dogs.
Well, but and the boards of directors are usually so reasonable, efficient, and everything. And some crazies out there show up and they say, well, you know what? I need this iguana. as a companion pet. And then there they are, walking around the common area with a 6-foot-long iguana, right?
Well, I got you.
You know what I'm
right.
saying, though?
Well, there's the full spectrum of when it comes to any law and the enforcement, and when people can unduly take advantage of it, right?
Yeah.
They can
Well, I
be
mean,
not
could
so
you
honest, but
Right.
but on the other hand, so we got the full spectrum. We're not going to until we have the facts in front of us. So we need to do a proper analysis because the board of directors has a fiduciary duty to make sure that there's no one cheating when it comes to having pets at their development. Now, I want to contrast the joint statement I just said. The joint
Go ahead,
statement
do that.
with the other one that concerns reasonable modifications. So we got reasonable accommodations versus reasonable modifications. Reasonable accommodation is when the association must grant the owner, tenant, the ability to not comply with a particular CCR provision or rule. Whereas a reasonable modification is when an owner comes up to the association and says, I want to put in something to accommodate my disability, such as
a jungle gym for my pet monkey. No,
okay, a dog run. I was going to say a dog run.
All right, dog run. Okay, so Frank's given us the cue that we're going to go to break. And then I think when we come back from the break, you've got a couple of little things that you want to just clear the air with, but they're important facts.
We have more law.
Information.
We have more law. More
free law from an attorney. Never hear that phrase very often. So we're going to be back from the break. We got Norm and Liz. We'll be back.
Hi, I'm Morgan Fussell. My company, Broadband Agreements, negotiates cable television and broadband right of entry, access, and compensation agreements for your communities. At Broadband Agreements, we offer a free review of all agreements with a signed letter of authorization. Broadband Agreements will improve your community's income and/or savings, or you don't pay us a dime. Visit us at broadbandagreements.com. That's broadbandagreements.com. Or call me, Morgan Fussell, directly at 916-939-5026. That's 916-939-5026. Broadband Agreements online at broadbandagreements.com or 916-939-5026.
The challenges presented by today's economy and rebounding housing market is forcing many homeowners association boards of directors to operate their HOAs more like a business. It's a balancing act of trying to stay solvent and still provide homeowners with quality amenities and services. One of the main challenges HOA boards are facing is attempting to recover unpaid HOA fees owed by delinquent homeowners. Collection efforts are often very time-consuming. If you want to get the HOA fees collection monkey off of your back, call ATC Assessment Collection Group. ATC is an attorney-supervised collection company providing collection and foreclosure services to HOAs in both California and Nevada's most recognizable communities. Get back to what you actually volunteered to do as an HOA board member. Effectively oversee your community. Call ATC today at 916-641-1410. That's 916-641-1410. Online at atcacg.com. That's atcacg.com. ATC Assessment Collection Group. Professional Parking Enforcement, or PPE, was created to provide effective parking solutions for all types of parking issues. PPE focuses on parking problems of HOAs and can quickly eliminate these problems through their system of property inspection, violation updating, ticketing, and enforcement. Contact PPE today at 702-283-0628, online at ppenv.com. PPE, promoting harmony in HOAs through parking and compliance enforcement. We take time to understand your community's needs.
Silver Creek Association Management.
We solve small problems before they become big ones.
Silver Creek Association Management.
We help make your community a better place to live.
Silver Creek Association Management.
It's what we do, because an association is more than just a bunch of homes. It's a community of people. We work with you to make better communities so homeowners can enjoy better lives.
Silver Creek Association Management. Online at sc-manage.com. That's sc-manage.com.
This is AM 1380, The Answer.
Oh, we're back from the break. I'm sorry, I was enjoying the music playing here in the beautiful studios of 1380. But I'm more excited because we have Liz and Norm on the line. Are you guys still with us?
Oh, yeah.
Did you
Still
learn
here.
anything thus far?
Yes. I've heard everything.
I know, and you're taking it, hopefully, this information, and you're ready to battle it out and win some gift cards?
Absolutely.
Absolutely. Counselor, did you have a couple little things real quick?
We do.
All right.
We have a little bit more information, and then we'll go to the game. The law that we are talking about, 4715, Civil Code section in the Davis-Stirling Act, it also provides that if an association does go ahead and implement a rule restricting the number of pets that an owner may keep, well, the new rule is not going to apply to prohibit an owner from continuing to keep any pet that the owner currently keeps. So the owner could keep, let's say the association adopts a rule limiting the number of dogs someone can have to 3, and an owner has 4 when they adopt a rule. This rule will not provide that the owner has to get rid of 1 dog. Okay? Okay.
That makes sense to me.
All right. So when 2 small points then regarding tenants, owners coming to the association and making a request for an accommodation to the rules, a pet request, we'll say. And in this case, the owner says, it's because of my disability. So the association board of directors, manager, they have to do an analysis. They have to do an analysis. If it is obvious to a person that another person is disabled, okay, if the person that's coming to the board of directors, it's obvious what their disability is, then the board of directors can't ask for information about it, open and obvious. Or, slight twist, if it is known that the tenant, resident, owner at the association is asking for the accommodation, if it's known they're disabled, the board of directors manager cannot ask more information about it. If it's you can't tell the disability, then the association board or manager can indeed ask. Now, the second point is, before we get to the game, is in order for a person to get this reasonable accommodation to the rules, to allow them to have a companion pet because of their disability, they must be disabled. And number 2 is there must be a relationship, also known as a nexus, with an N, nexus, a relationship nexus between the disability and their request for the reasonable accommodation. All right, so examples in this Department of Justice /HUD joint statement
HUD?
is when an owner comes to the board of directors in a wheelchair, right? Wheelchair. And they say, well, I would like to have a dog as well. The board of directors can say, this isn't my opinion, all right? This is in the Department of Justice /HUD joint statement, and they say that you can ask for information because there didn't seem to be a connection between the dog. They can see the owner's disabled with a wheelchair. Okay, so there can be some information that they can explore. We got a text too, and they said, we'll clarify the difference between a companion pet and a service pet. So a service is trained for a disability. A companion pet, absolutely, it means it has no skills. Now, it made me think that a service animal could be a companion pet as well. All right.
Got it.
I think we covered everything. We have 2 great board members, and I apologize if there are questions.
They're sharp, though. I'd be
All right.
surprised if they knew answers to questions we didn't even cover. Right, Liz and Norm? Are you guys ready to play Battle of the Board Members?
Sure.
Yeah, we're ready, I guess.
All right. Well, I'm going to take Liz today because I think she's going to win. So I'll let you.
Okay.
I'm going to let you go first round with Norm.
All right.
How's that?
Okay, great. So, and what will they win?
$100 gift card of their choice for first place. $50 gift card of their choice for second place. There's no losers on the HOA brunch. Well, except for Frank in the back, but we'll talk about that later.
All right. So yeah, these are really tricky questions. So starting with you, Norm, are you ready? It's going to be 3 questions. So this is not Liz, this is just Norm. These are really difficult questions. Norm, are you ready?
Yeah, I'm ready.
All right. Okay. So question number 1. If an association adopts a CC&R amendment restricting the number of pets, the amendment will not require an owner to get rid of a pet. True or false?
Well, say that again?
Yeah, if an association adopts a CC&R amendment restricting the number of pets, the amendment will not provide that an owner must get rid of a pet.
That's false.
That one is true. So that's the grandfather clause. I told you these are difficult.
Oh,
you guys.
the grandfather clause. You're right. Yeah, you're right.
All right. So the second question is, an association must pay for a reasonable accommodation granted to a disabled resident. I didn't cover this, so I apologize. We'll have to give a little explanation. So I would just say yes on this one, but an association must pay for a reasonable accommodation granted to a disabled resident.
I'd say that's true.
Exactly. Good job. Yeah. So if an owner wants a reasonable modification, then the owner has to pay for it, but a reasonable accommodation. So excellent. Good job, Norm. Question number 3. A rule prohibiting residents from keeping dogs is enforceable.
It's true.
That's right. Excellent job. It's just straightforward. Perfect. So that first one was difficult. And what's the score, Jonathan?
Norm's got 2. He's up 2-0. But, Liz, I got a lot of faith in Liz. So, Liz.
Thank you.
Are you ready?
Yes, I am.
All right. So we got 3 questions for you, true or false. I got a lot of faith in you, so we're just going to buzzsaw our way through these. So you ready, Liz?
Yes.
True or false? It is. Okay, so an association must pay for a reasonable modification granted to a disabled resident.
True.
Got it. A service animal is an animal that is individually trained to do work or perform tasks for a person with a disability.
True.
Got it. It is unlawful to ask a disabled person why they want a companion pet.
Say that again.
It's unlawful to ask a disabled person why they want a companion pet.
Yes.
Wait a minute. I think that's
false.
That's
false. Right.
Yeah. So
right.
it's 2-2. All right. Second round. It's tied up.
Well,
Liz,
let's talk
we're
about
all
that
right.
one for a second. We have a couple minutes. Okay. It is unlawful to ask a disabled person why they want a companion pet. If it's not open and obvious, you can ask. Absolutely. Okay. Round 2.
So that was true. Right?
No. So the question is it unlawful to ask? It's not true. It's false. Okay. You can't ask a disabled person why they want a companion. You can't. Okay. So tied up.
Okay.
Tie game. All right, Norm. Back to you. 2 questions each. So Norm, this is back to you. An association may not require a resident with an obvious need for a companion pet to provide written documentation of the need. Let me say it again. An association may not require a resident with an obvious need for a companion pet to provide written documentation. True or false? Norm, what do you think of that one?
Well, I guess that's true.
It is true. All right. Excellent. Last question for Norm. Residents who are granted reasonable accommodations to have companion dogs may take up to 8 hours to clean up after their dogs. Residents who are granted reasonable accommodations to have companion dogs, heck, they can take up to 8 hours to clean up after their dogs.
Is that a question?
That's a question. True or false, Norm?
That's false.
That's correct. Okay. We got 30 seconds.
All right, real quick, Liz, 2 questions. But I think the counselor says, you know what, there's such great contestants and board members. Everyone's a winner. We're just going to take care of you with gift cards. Okay, so, Liz, associations may ban all snakes. True.
What?
Associations may ban all snakes.
All right. After hours it is.
True.
Perfect.
All right.
Tie game.
We're out of time.
I'm Nick Soboleski, a Select Quote agent with a true story that could save you hundreds of dollars a year. A woman named Linda just called. Her husband, Ray, has a $300,000 group life insurance policy, but is changing jobs and can't take it with him. Well, I impartially shopped the highly rated term life insurance companies we represent and found Ray, who is 41 and takes medication to control his cholesterol, a 10-year, $500,000 policy for under $26 a month. That's almost twice the coverage for less than half of what he had paid. If SelectQuote hasn't shopped for your life insurance, you're probably paying too much.
For your free quote, call 1-800-423-4557. That's 1-800-423-4557. 1-800-423-4557. Or go to SelectQuote.com. We shop. You save. Get full details on the example policy at SelectQuote.com/commercials. Your price can vary depending on your health, issuing company, and other factors not available in all states.
The hometown advantage. You can see it in that new shop down on Main Street, in the office downtown, the factory by the river, and the farm down the road. It's because of people like Reggie in finance and Ruth, the paramedic. Keisha, the designer, has it, and so does Orlando, the nurse. They live around here. They care about this community. They work hard to succeed, and that makes a difference. At SacramentoHelpWanted.com, we're proud to work the hometown advantage. We work it around the clock, connecting local employers and local job seekers with local jobs they're good at, jobs they deserve. Post your job today and search a database of resumes to find, select, and hire the best local employees. Employees who live close by, close to family and friends, close to home. That's the hometown advantage. SacramentoHelpWanted.com. Local jobs that work.
A calling to a life of ministry is not for the faint of heart, and studying to be equipped for it is not any less challenging. It can involve long days in class, endless nights of studying, countless cups of coffee, and hundreds of pages read. With professors who are experts in their fields, we are certain the time you put into your education will give you the training you need to become the ministry leader God has called you to be. At Epic Bible College, we enroll applicants year-round and can get you started towards earning your degree right away. We have morning, afternoon, and evening classes available to meet your scheduling needs, along with both online and on-site degree programs. At Epic, our passion is to train you for ministry both locally and globally. With an AA, BA, and MA degree through our online or on-site course study, you can get the instruction you need from an accredited institution. Visit us online at www.epic.edu. That's epic.edu. Journey with us through the entire Bible, every book, every chapter. Epic.edu.
If you have sore joints, discover a breakthrough in joint health. Cosamin ASU. A unique patented formula, Cosamin ASU goes to work fast on a cellular level inside your joints. Its active ingredients are shown to inhibit specific enzymes that break down cartilage as you age, helping protect the joint cushioning cartilage important for comfortable activity. Try Cosamin ASU at Costco.com and other fine retailers.
This is AM 1380, The Answer, KTKZ, Sacramento.